Yes, Mr. Rao, I can see you back.
Yes.
That was very brilliant
So,
introduction. Just proceed.
okay, I mean, quickly, please stop me if I don't finish in less than 1.5 minutes or 2 minutes.
No, just proceed. You have all the time now.
Yeah, so the doctrine of complementarity. Now we are going to deal with the situations, number one, of a country which was a state party initially, but withdrew after perhaps, I mean, then the duration of relevance, which the court considers, the majority considers as from until a day before they withdrew in 2019. That is one situation. And our director has referred to another situation where you might be dealing with a country which is not a state party. This is about, again, the investigation issue, which is that Ukraine-Russian situation, where one country is not a party at all, ever, but is a member of the Security Council, which under the Rome Statute, for me, it was a controversial position at that point in negotiations, in diplomatic negotiations,
Yes.
to give Security Council the control to refer and to save the permanent members from the jurisdiction if they so wish. I mean, it's like, because indirectly, veto applies in Security Council, so veto applies against the Security Council members because they can put a veto on that.
Yes.
And we have not yet come, let's not hypothesize on that, but we have not come to that situation. But this is a situation which we, in 1996 to 1988, argued in the PrepCom and the diplomatic conference as well. Anyway, there are several reasons. So, but this is certainly an interesting juridical issue and a jurisprudential issue as well, to consider how the state, which is a party but walked out, and the investigation belongs to a transition period before the state party walks out.
Yes.
And of course, we have the majority judgment 322 in the ICC, in the pre-trial, not the jurisdiction, but the preliminary issue decision. So it is fascinating, and I will stop because, as I said, I don't know much. I'm only curious to know. I didn't want to even put on my...
No, we're enjoying, actually. You are pumping in a lot of wisdom, and please feel free to proceed. Feel free.
Okay, no.
Yeah.
No, I would rather listen to others, and then if I want to respond, I will come back. But the issue of the principle of complementarity,
Yes,
and the transition period and non-state parties issue. Non-state party once has been a party, but now not a party. And that vis-a-vis a situation where ICC might need to deal with, or is dealing with at the prosecution and investigation level, about a country which is never a state party, but is a controlling authority in the Security Council, being a permanent member. So we have different situations coming up, and this is a fascinating phase for ICC, because I knew I was never into the court, but I knew so many of my friends became the judges and the presidents, both men and a woman, and they are retired. And colleagues of mine became the heads of the legal division in the ICC and the prosecutor's side. So I will stop on that. I only have fond memories of my colleagues in the ICC process. The last I was there was at the inauguration of the court in The Hague. Anyway, thank you, my friend, and very kind of you for giving me this opportunity, but I never intended this, honestly. Thank you.
Thank you very much, Mr. Rao. That was very, very brilliant. And I believe some of our two colleagues who are also with you at the Rome Statute conferences, Professor Alejandro Ranciotti and Professor Mercedes Pisani, would be very excited to hear what your contribution has been. Very short and very brilliant. We've enjoyed that part. The issue of complementarity, as you've just indicated, is a very, very controversial issue. There is the offshoot of complementarity, which is positive complementarity as a policy, which my doctorate actually was based on positive complementarity. We can see that the new prosecutor, the ICC prosecutor, Karim, had visited Southern America with the intention of trying to advance the issue of positive complementarity. Because the classical complementarity apparently might be having its own shortcomings. Now, we can see that the basis of the decision of the appeals court, appellate jurisdiction of the International Criminal Court, tended to revolve around basically around the principle of complementarity in one of their bases for the decisions. But let me not go, all I'm just trying to underscore is the critical contribution you've just made. Much as you're not recognizing that it is very critical for us, it is very important, and I'm very happy, and I'm sure many of our viewers and our panelists are very impressed. We can see we have Dr. Marotta back online. Dr. Marotta, can you hear us? Yeah. Dr. Marotta, are you with us?
Yes, I can hear you. Yeah.
Good. Thank you for getting back online. We've just had a very brilliant contribution by Mr. Rama Rao. And of course, we'll have a recorded version of this discourse shared. And Mr. Rao, don't forget to provide us with your email address right now or through whichever means, so that we'll be able to share the video with you. Okay, I want to hand you back over to Dr. Giovanni Marotta, our international programs, the international legal consultant and a specialist in international human rights law and international criminal law for further advancement of this matter. Over to you, Dr. Marotta.
Okay, thank you. So we connect again. So for summing up that what we have discussed today, it's important that every international legal practitioner in the field, scholar or lawyer, we need to analyze. Okay, we need to analyze and to be like, reading and checking every movement from now on to the future, what the ICC is going to do or is doing. We need to understand that we have a very proactive prosecutor office. I remember that it was 2 years ago that we have a panel discourse related to the election of Karim Khan. So I'm not surprised how the prosecutor office is working. It's very proactive. And so, however, during this proaction of the prosecutor office, we need to be very, very, very wise and to give assertive opinions related to the work, how the prosecutor office is working, and in general how the International Criminal Court is working. Because before the administration of Karim Khan, the prosecutor office was, it was like I don't know, it was it didn't have too much action related to some cases, but now it has. However, it needs to comply with the law. He needs to comply and work through the rule of law. So it's important that I see that they are going to tune up how they need to handle the work from right now to the future. So this kind of dissenting opinion is very important, and also what is important is to discuss other things. That's the reason why we do this panel discourse with Professor Milton, for example, related to the defense team, and also for the ICC international I think is the name is it's not international board, it's international bar. How how the work also how the work they are doing and aiding the ICC. So I think that from now on to till I don't know until the next the new or the one who's going to replace Karim Khan. I mean, I hope that this way of working will continue and it's not going to be like a blink in the sky. So however, I mean, we need to be very under our international experience and knowledge. When we need to say they're doing the things that they are doing good, we will say that. But if they are doing something wrong, we will point out so they can meditate, see what's going, why they did that, and they can improve the work they're doing. So but that's what we are going to see because the work and all the how they're managing Ukraine, Georgia, Sudan, the Philippines. What we're going to see in the coming months related to Venezuela. Also, we're going to see some action over there. So we need to be have the eyes very open and to see if they're complying with everything that the law requires in international criminal law, the Rome Statute. So when a case is going to pass for trial, it will finish and not will be taken down because during the pre-trial chamber investigations it didn't comply with the Rome Statute, and that will be very sad. So the idea is that in every step they go complying with everything that is in the international treaties, in the international case law, obviously in the Rome Statute, and everything that has been written and everything that has been studied. Thank you, Professor Milton. I pass the floor to you.
Thank you very much, Dr. Marotta. That was erudite. We appreciate your contribution. I want to get back to you, Mr. Rao. Mr. Rao, are you still there with us?
Yeah, I'm here. Yes, but
yes, there is something of interest that I would want us to learn from you, or our viewers to learn from you. You indicated you are part of the conference that engendered a very critical document, that's the Rome Statute, and that is very, very important. So I would like to ask one thing. You see, the essence of the decision of the pre-trial chamber and the appellate jurisdiction of the International Criminal Court with respect to this case tended to touch on the issue of Article 18.2, which deals with deferral in the sense that when the prosecutors launched investigations, has actually gotten authorization for investigation, the party concerned would still approach the same prosecutor and indicate that it seeks a deferral of the matter. And in that case, the prosecutor does notify the pre-trial chamber that the concerned state party has given notice of deferral, and they would have to scrutinize whether there's a basis for that deferral to be sustained. You have mentioned two very critical issues in your presentation. One of them was on the issue of complementarity And you mentioned, you talked about very important issues on how complementarity was addressed, and the issue of, there are other many issues that you mentioned. I would want us to revisit the point, your recollection during your negotiations. What were really the challenging issues where the contention? Because we can see now 3 judges against 2 have a contention over the issue of whether jurisdiction could be exercised over Philippines in respect of the period within which the scope of the crimes were committed. Just out of interest, any other recollection you have during your time of those important negotiations that gave us a very important document, and thank you very much for that, the Rome Statute. Anything that you might wish to share with our viewers would be appreciated. Let me not confine you to any limit or any particular area, but whichever area you feel would be of interest, would appreciate if you could address that. Thank you very much, Mr. Rao.
No, thank you, very kind. Sorry. Okay, thank you, very kind of you. But one is the issue that you raised is the procedural issue about the trial chambers and essentially at that, the only thing I can recollect at this point in time quickly on that issue is I'm a common law guy. So in terms of procedures, we know about the common law substantive criminal codes or the penal codes that they came from England those days, which was like a century or 2 centuries back, particularly to India. And then the procedure codes, criminal procedure codes. But we are not familiar, I'm confessing something here, we are not familiar with the civil law criminal system or civil legal system criminal law and their procedures. So actually, I'm more a substantive character at that time in the negotiations. I had one of my junior fellows who also became legal advisor and retired. And I used to leave him for the procedures, like mutual legal assistance, extradition, which criminal thing will apply, blah, blah, blah. There are a billion day-to-day matters that happen in the international criminal jurisprudence. And the practical ways of dealing with the criminal and bringing him to the justice and bringing him to whatever the penalties, punishment, etc. That is the procedure side. And I was not involved. And eventually, my feeling was, at that point in time, was that the procedural aspects were more civil law injected into the statute than the criminal law. And that didn't bother me because I had so many other substantive issues to deal with. So that's one thing. Then another, I'll remember, I mean, I was focusing on the substantive, but I think you have raised I was more focusing on the procedure things now, but I think you raised some substantive issue as well, which I'm not able to recollect right away. Sorry.
Is it the deferral? Deferral, it entails both substantive and procedural aspects in a way. But anyhow, just feel free.
Yeah.
And as I told, don't
okay.
confine yourself. You are feel free to touch in any area that your recollection brings it. That's very critical for us.
Yeah, I mean, of course, as I said, I have raised some substantive issues of contemporary importance in my previous intervention, which is the transition from party to non-party state party issue. And
Yes.
number 2 is non-state parties. And number 3, related to the second issue, is non-state party with the status of a permanent member in the Security Council,
Yes.
whether it's
yes, yes,
XYZ or two other, because there are a total of 5.
yes.
So,
That was a very important issue raised there, which I think
yeah.
you may want to highlight.
And then, of course, the jurisdiction of the court is limited to the crimes that have been enshrined in the statute.
That's right.
Okay. Now, originally we had few crimes, whatever, 5 or so, or 4. Then we have added in Kampala another one called aggression.
Yes.
Now, I don't want to go into the history, but aggression was raised during, I don't remember the ad hoc committee, but certainly during the preparatory committee time. Though, and then we know the context, and we have, all right, that context we know. And then there's a lot of diplomacy behind how to get it in. And then after the adoption of the statute in Rome, and after the court entering into force, the statute entering into force, still it took another door was opened for renegotiation of the crimes, and then inclusion of aggression took place in Kampala. Now, at least in the last 20 years, I mean, even during the time of the adoption of the Rome Statute, there was another substantive crime that was being raised by some countries, including India, which was not adopted, and on which there is no provision even today, and that's being dealt with directly by the Security Council now. And in the General Assembly, in the UN Legal Committee, there used to be a body to deal with that, to codify that crime, and then it related not to the general category of international crime of that particular nature, but with reference to the funding and with reference to the nuclear aspect of it. There have been 2 conventions that came. Now, there is a gap. Some think there is a gap in the substantive law of the corpus juris in terms of the crimes itself.
Yeah.
So now, given the proactive nature of the current chief public prosecutor of the ICC, hats off to him, Karim Saab, that he is now, we don't know if there's going to be any action later, because, yeah, anyway, I'll just stop there. Thank you.
That is very brilliant. Thank you very much. I think within a
Thank
short time, our viewers have learned so much from you, much as we've been learning from our other 2 experts. As I told you, you might have met Professor Alessandro Lanciotti during your session from Italy, represented Italy, along with Professor Mercedes Pisani, also represented Italy. They've been very helpful, much as you've been very, very, really.
I'm sure our Italian colleagues remember. The Italian leader of the delegation at that time, Mario Politi, who used to be the legal advisor in New York. When I was the legal advisor of the Indian mission here in New York, and Mario later became a judge and president of the court. So I'm sure they worked with him. So I will stop here and welcome to them. Welcome to them.
Thank you so much, Mr. Rao. I appreciate so much.
Thank you. I will be following, but I will mute.
Okay. Now, Mr. I want you to note that on Wednesday we'll be having a session on the Ukraine, and I think that is where most of our members are going to appear. The panelists will have it 1 hour earlier than the scheduled hour. We'll announce that very soon, and we still hope that you'll be able to come and attend. I wish to hand us back to Dr. Marotta if he has anything else to add on, and let's see if there's anything to add on, so that we could also reinforce what Mr. Rao has just indicated. Mr. Marotta, can you hear us?
Yes, I'm here. I can hear you.
Okay.
Yeah.
All right. Is there anything else that you want to reinforce on?
No, it was very interesting what Mr. Ramarao has shared with us. His experience as a legal practitioner, how about the common his background in the common law, and how he differs to understand the civil Roman Germanic
Yes.
system in the criminal, how it works. It works totally different. I mean,
Yes.
That's the mix that has the Rome Statute from the International Criminal Court. It has integration of the criminal law procedure from the common law, and it has the criminal law procedure from the civil Roman Germanic system. So yeah, it's interesting. I will write it down. We can make a panel discourse, not now, not nearby, but we can in a month, related to that, how to analyze how it works, the criminal procedure common law system and the Roman Germanic criminal civil law system. So to understand how it works. So for concluding, it's important that, as I said previously, is that we need to be like the watchers of how the the prosecutor office of the International Criminal Court is working, and also how the pretrial chambers assigned to different cases are doing their work, how they are, so to see if they are in the right path or not. So that's the idea, to make the discussion, to make suggestions and everything related, because from my point of view, we are going to see more action coming related to international crimes. Also, what is happening in Switzerland, that they are applying to universal jurisdiction, such as Germany, as France, and also what we are going to see related to universal jurisdiction. It's more about related to human trafficking, related to children. What this movie Sound of Freedom has shown us. So we are going to see also from national courts trying to do investigations against international criminals related to human trafficking with children, applying universal jurisdiction, and we're going to see something. And also we need to be very, very assertive, follow up all those kind of cases, because sometimes in the eager of doing good, sometimes during the procedures against against due process, against constitutional cases and everything, cases that are important to prosecute sometimes cannot be done. So that's something that we have to be very assertive in doing our watching and trying to give opinions and how it should, and how from now on the international criminal law prosecution, not only before the ICC, also in national courts under universal jurisdiction, must follow. So everything that the work that in international arena to fight international crimes are trying to do, they will do in a very sensible and smart way to go, because if they get eager and enthusiastic to do things and they don't follow the book or the law, the case law, or if they want to do something that needs to be, do very quickly, they need to be very smart. So the other side cannot use everything that is going against that one. That's what they are trying to do. Okay, Professor Milton, thank you. I pass the floor to you.
Thank you very much, Dr. Marotta. Giovanni Marotta is based in Europe. He's currently in Spain and is also based in the Netherlands. Thank you for your attendance. And Mr. Rao, Dr. Rao, who is based in New York and has been part of the Rome Statute, process. They are the team that generated for us a very important document, the Rome Statute. I want to thank you so much. I'm based in Johannesburg, South Africa, and I hope to see you in the next session when most of our panelists will be in attendance. We'll be dealing with the situation in Ukraine, the Russia-Ukraine war. And we'll deal with issues that Mr. Rao has also raised about the Security Council issue, our members, and we'll look at the trigger mechanism, which one of the 3 trigger mechanisms are referred by the Security Council. And also the issue, we'll revisit the issue of non-state parties, getting involved in procedures, being entangled within the procedures of the International Criminal Court. These discourses are very critical because we reinforce the work of the International Criminal Court, we support the work of the ICC, and we criticize where critical for constructive purposes. We have well-accomplished professors on this panel, some of whom have taught international law for over 30 years. And we look forward to meeting the whole team on Wednesday, the 26th of July at 1 a.m. South African Standard Time. Initially, it was set for 2 a.m., but because of we have in South Africa, there is a load shedding issue which keeps disorganizing us technically. So we want to make sure that there's no interruption. I want to thank you once more, Dr. Marota, our international program director, and I want to thank you, Mr. Rao, a well-established and experienced consultant and founder among those who formulated the Rome Statute. Thank you all our listeners, thousands of our listeners on all our other platforms for being with us today, and hope to see you again. For now, bye-bye, and
Bye.
hope to see you.
Bye. Thank you. Thank you so much. Thank you so much.
Thank you. Bye-bye. See you on Wednesday. Have a nice